States Exhibit 1, the Twitter page.
Your Honor, defense objection about hearsay in 403.
Your Honor, as may be heard. Court.
Let me take a look at the rule real quick. The rule 403, counsel?
Yes, Your Honor.
Let me hear you.
There is a certain inflammatory language contained within these Twitter messages, specifically those purporting to come from Sally Dratt, in which she says that my father would kill me if he found out. We find that this is an inflammatory language that could lead to improper inferences by the jury, in which this is the danger of unfair prejudice would substantially outweigh any probative value of such statements.
So your concern is just the prejudice over value?
In addition to the fact that it is hearsay, Your Honor.
As to hearsay, Your Honor, this isn't being offered for the truth of any matter asserted within, but rather for the effect it had on the reader of the investigation. Here, we anticipate that Mr. Stocker will testify based on what he saw here. He called the defendant John Draft because he saw Sally Draft in the Twitter message, and so he made the link and decided to call somebody who he knew to be her father, John Draft.
So you were saying this is basically a piece of the puzzle for investigation purposes?
That's correct, Your Honor. So it's not offered to prove any truth of anything said within, but rather to show what he did afterwards. Your Honor, for that same essential reason, we would argue that this does not violate Rule 403. This is not going to inflame anybody's passions based on a statement that a teenager makes. My father would kill me. Teenagers all the time make statements. My father would kill me if he saw me with his car. My father, it's, just a colloquialism, Your Honor.
Your Honor, may I be heard? Sure. Under normal circumstances, that may be the case. However, we are dealing with a murder trial. Inflammatory language in that regard can lead to substantial unfair preferences by the jury, and as such will unfairly prejudice the defendant.
How about we let it in for purposes of fitting the puzzle for Mr. Stocker here to how it led to a potential suspect, but move to strike any verbiage or wordage for the jury to hear. So move to strike the actual language in the Twitter.
So to redact the inflammatory language?
Correct.
That is acceptable for the defense, Your Honor.
Your Honor, look. We'll cover the language about my father will kill me.
Okay, I move jury. You're not allowed to consider what the actual.
It's actually been redacted.
Okay. So,
Permission to publish the redacted documents as your.
yeah, fine. Yeah, counsel.
Mr. Stockard, would you describe for the jury what that is?
Sure, that's Mr. Walker's Twitter account, specifically the page that shows him exchanging Twitter messages with Mr. Walker's daughter. Mr. Draft's daughter.
When you saw this Twitter page, what, if anything, did you do afterwards?
After seeing this Twitter message, we identified Mr. Walker's age, and then I called Mr. Draft to determine his daughter's age.
How did you know Mr. Draft's number?
Well, I have been dating Mr. Draft's wife, Pam.
How, if at all, did that relationship affect your investigation?
Not at all.
When you called Mr. Draft, would you describe for the jury that conversation?
Sure.
For example, you were dating who, sir?
The defendant's wife, ex-wife.
Thank you.
Would you describe for the members of the jury the conversation that you had when you called Mr. Draft?
Sure. I called Mr. Draft. I asked him how old his daughter was. He told me she was 17. And then I told him that Mr. Walker had been killed. And the first thing he said was, I didn't do
Mr. Stockard, do you recognize Mr. Draft here in the courtroom today?
Yes, I do.
Would you point him out for the record based on where he's sitting and something he's wearing?
Sitting over there, wearing glasses, dark glasses.
After you called Mr. Draft, what, if anything, did you do next?
Well, after speaking with Mr. Draff, we executed a search warrant on his house to discover any small caliber firearms.
And what, if anything, did you find inside his home?
Inside his home, we found a receipt for .32 caliber ammunition.
Objection, witness testifying as to the contents of the document that is not admitted into evidence.
Your Honor, the witness is just describing what he saw.
Do you have a rule, counsel?
Yes, Your Honor, the objection would be hearsay.
Okay. To a document that he's,
To the contents of a receipt describing the item purchased. The witness is testifying as to that document which has not been admitted into evidence.
so counsel, do you have a copy that you can show?
We do, Your Honor. Actually, the record will reflect an approaching opposing counsel what's been marked for identification as State's Exhibit 2.
Well, Your Honor, as the objection stands, your statement ruling may ask that the testimony that was elicited regarding that document be stricken from the record.
Sir, please write in black.
To the extent that it was for a certain amount, but
Yeah.
then he found a receipt.
What do you found received from where and so forth, and for what?
May the record reflect an approaching opposing counsel with what's been marked for identification purposes as State's Exhibit 2. Your Honor, you'll find this in your record at page 33, also with a tab that says Exhibit 4. May I approach the witness? Mr. Stockard, do you recognize what I've just handed you?
Yes, I do.
What do you recognize it to be?
It's a receipt for ammunition that I found.
Without getting into the contents of it,
It's a receipt I found at Mr. Draft's home.
how do you recognize it to be that?
It looks like the receipt that I found at his home on the day that we executed the search warrant.
You said it looks like the receipt. Is this a fair and accurate copy of the receipt?
Yes, it is.
Or this time I move for the admission of State's Exhibit 2.
Our defense again objects regarding hearsay and Rule 403.
Interesting. Hearsay again, this is offered for the effect it had on the investigation. We anticipate that Mr. Stockard is going to testify that based on this, he continued to investigate, or continued to search the apartment, he searched the person of the defendant, and that he ultimately arrested the defendant. Also, Your Honor, as to Rule 403, this is really a matter of weight and not admissibility. Nothing about this is particularly inflammatory, and any deficiencies in the link between Mr. Draft and this document can be explored on
Is
cross.
that document the actual document or the copy of the document?
Your Honor, based on the stipulations in the record, this is the original.
Original document, okay. And do you have anybody here from the States and Ammo to?
We do not, Your Honor, although all of these exhibits have been stipulated as authentic.
Okay. And counsel, again, your objection is this hearsay?
Hearsay and Rule 403.
And you want to clarify that further?
Sure, Your Honor, as the fact that this document is being offered for the truth of the matter asserted that whoever is in possession of this receipt was in possession of .32 caliber ammunition. In addition, probative value substantially outweighed by any danger of unfair prejudice, as the receipt is more than 5 years old at the time of the crimes alleged. As a result, any probative value that substantially connect this receipt to the crimes alleged is nil. The potential for unfair prejudice is very high in this regard because it will be taken out of context from 5 years prior.
I'm going to overrule that. I'm going to say that this receipt doesn't indicate who purchased the ammunition. All it is they found a receipt in the defendant's home. I'm going to come in.
Yes, Your Honor.
Commissioner published adjourned. Mr. Stockard?
I apologize. Opposing counsel did offer this not for the truth of the matter asserted.
Correct.
That's the limiting instruction to be issued to the jury.
Do you hear that?
Mr. Stockard, based on what you saw here in this receipt, what, if anything, did you do next?
We arrested Mr. Draft.
When you arrested Mr. Draft, what, if anything, did you do with his person?
Well, we searched his person and we found a .32 caliber bullet in his pocket.
Objection and proper opinion.
Hey, can you repeat the question?
I asked him what, if anything, he did with Mr. Draft next. He said that he searched and found this .32 caliber casing.
What's your objection now?
The objection is as to a proper opinion as to assessing the size of the caliber bullet. In fact, the court has already made a ruling on this
Correct.
very matter.
Sustained.
Motion to strike that portion.
Motion granted.
You testified that you found a shell casing. How, if at all, did that differ in size from the shell casing that you found at the scene?
Just from my personal opinion, they looked about the same.
And how, if at all, did it differ in weight?
From
Objection, proper opinion.
Your Honor, this is a lay opinion. He handled both of them.
Correct, I believe a person can say how much it weighs.
about the same.
Overruled.
Based on your perception, what, if any, differences were there between the two shell casings?
Based on my perception, I didn't notice any differences between the two shell casings.
What, if anything else, did you find in the apartment when you conducted your search?
So in addition to the things that I mentioned, we found one pistol range target that had been used. We also found a printout of a Google map.
And what, if anything, did you learn from that?
From the Google map?
Correct.
Okay. So the Google map was, we found it at Mr. Draft's home, and it was a map from location A to B. The starting location being Mr. Draft's home, and then the destination being Mr.
Objection,
Walker's
witness
apartment.
testifying as to the contents of the document that is yet to be admitted into evidence.
I will consent to striking the locations. For the record reflect, I'm approaching opposing counsel with what's been marked for identification as State's Exhibit 3. Okay. And you'll find this in your record, Your Honor, at page 38, also with a tab that says Exhibit 8.
Thank you,
Permission to
Your Honor.
approach the witness?
Permission granted.
Mr. Stockard, do you recognize what I've just handed you?
Yes, I do.
What do you recognize it to be?
It's a Google map that we found at Mr. Draft's home.
Without getting into the contents of the map, how do you recognize it to be that?
The map that you just gave me looks exactly like the map that I saw when I found it at his home.
And at this time, we move for the admission of State's Exhibit 3, the Google map.
Okay,
No objection, Your Honor.
admitted.
And would you explain to the jury how that map factored into your investigation? One moment before you do that. Your Honor, permission to publish this to the jury.
Sure.
Do you need me to repeat the question?
No. Discovering this map led us to believe that Mr. Draft was a prime suspect in the case and helped us in leading to his arrest.
What about the map led you to believe that?
Just the starting point and the destination on the map.
What were those?
The starting point was Mr. Draft's home, and then the destination was Mr. Walker's apartment.
How did your investigation end?
The investigation ended with the arrest of Mr. Draft.
Why did you arrest Mr. Draft?
Just based on the evidence, the shell casings, the map, the target range that had been used, and the messages that we found.
No further questions.
I'm sorry, you said target range? All right, thank you.
Investigator Stockton, you mentioned direct examination, thinking about Pam